UK-based private legal practitioner. Thank you very much for your timeline. Good morning to you.
Hello, good morning. And how are you?
I'm doing, and I hope you are too.
I'm well. Grace of God. Thank you.
One of the things we are trying to make sense of this morning is a decision that has been taken by the Canadian authorities in the case of Partey. In fact, there's a pending matter. I'm not sure he's being charged official or the court case has proceeded yet, but it's the basis for which Canada decided to deny him visa into their country. What do you think? Is it justifiable cause for that?
Thank you. Thank you for having me. And greetings to your listeners this morning. Well, it's in twofold, this matter. And since it happened, I've had people calling me a lot on it. I got the news very early on before it even came out through Kofi Ochidako, because he was in touch with them straight away. So Kofi called me and we discussed it. Now, the elements to this is, which I've seen a lot of people talk about, is you seem to be saying that a person is guilty even before trial begins. And giving you the backdrop to the story slightly, the trial has not even begun. In fact, in criminal trial in the UK, we have the case management conference, which we call the pre-trial and preparation hearing. Now, we are at that stage. We finished. He's made his plea, said he's not guilty. And prosecution is now going to put everything together. We will see the trial strategy, what goes in, what doesn't go in, and all that. So both defense and prosecution are going to sit down and see what exactly will come to trial, because we're not going to take everything wholesale and take it to trial, because we have to get strategy that this is going in, this is not going in, this is agreed fact, this is not agreed fact. So the ones which are not agreed, then that's what we're going to deliberate. That's what we'll go to trial. Then we come to an end. So the case is so far from he being innocent or he being guilty. So the question is, if this is the reason, why does it get to this point that he's been denied visa? Now, this is what I'll come to. There's a criminal element as you being charged, and there is an immigration element. Mind you, the immigration doesn't go into the criminal matters. The criminal matters will always be what we all know, that proven beyond reasonable doubt. If there's a slightest of doubt, the person is not guilty. On immigration matters would go in the way as if civil matters go, which would be on the balance of probability. So even if the judge or whoever is taking a decision think that you may have done it or you may not have done it, the onus will lie on them to say that, listen, we think that you are a person not admissible in our country. And from where it stands, I believe that is the direction Canada is going. Now, we are not saying that you are guilty, no, but because you've been charged with this and it's hanging in the balance, we are going to activate our inadmissibility clause. UK does it as well. So if you fill in UK application form for people, I ask them all the time to disclose. And I've had clients who are that even matters as far as 1999, matters which are 27, 26 years old. But I have to make an application, sometimes a deportation order, to quash that deportation order, which doesn't expire, even before we make the application. So they tell me that, I did something in UK, I was deported about maybe 2021, 2022, and 2026. I'm doing well now. My circumstances have changed. I was a boy when I did it, and now they are holding it against me. Say yes. The reason is we have to quash it off. We have to deliberate it with the Foreign National Offenders Office. And when everything is clear before we go. So if I was making an application for the Black Stars, that is what I would even look into first, even before we make Partey's application. Because we know that the World Cup is going to Canada many months before now. And as soon as Partey's issue started, that is what we should have been dealing with the Foreign Office first in immigration before. Then they work out. You don't wait to put in the visa for the visa to be denied. Because you know that if they activate that, because mind you, he would not go beyond anybody else. Now this is the theory, and this is completely not law now. This is the theory. that I think may be going on. And this is only theory. Often than not, what I've seen is that if America agrees to the admitting someone in their country, Canada follows suit. And those of you listening to us right now who have American visas, 5 years American visa and all that, if you're making an application to Canada, you get a full duration of your passport, sometimes 10 years, sometimes 8 years. And you do not even have to add any documents. You have to quote the visa reference number on the American visa, and Canada follows suit and give you the visa. You don't even add documents. Those of you listening right now, they know. So it tells you that the information shared. In fact, in the past, when I even started practice, when you had American visa 5 years, you don't have Canadian visa, you could enter Canada. It has happened to me before. I had to go to Niagara Falls. I didn't have Canadian visa. I used American visa. I entered. Not anymore. So it tells you that those two countries share information so much. Now, if America has admitted Partey, why won't Canada admit Partey? No, I'll not speculate beyond this point, but think about it.
Okay. So typically, it's rare for
Pardon?
you're saying it's rare for the Canadian authorities to deny visa to someone who has already gotten an American visa.
Yes. Besides, it's needless. Of course, that's the law. That's the rule that they have. The rule to say that if you have something hanging over your head and we don't know where the balance is going to be tilting to, whether for you or not for you, against you or not against you, we will not admit you. They do it to a lot of people. I've seen it many, many times. I understand. But my question is, do we not have to? It's not cutting stone. It's balance on balance of probability. Do you really think that a person, reasonably, a person in his camp, a person going to play football for 1 or 2 nights and come back to his base in America would commit any offense at all? Or are you saying that we have prejudged the whole thing, and so therefore we cannot make a reasonable exception to this? Especially because America has the same rules, to be fair. Britain has the same rules. And if Partey is in Villarreal now, and Villarreal has to go to UK to go and play football, he will go. Nobody will stop him. Then they have the same rules. If he wants visa now, you'll get it. And the reason why Americans didn't stop him is because they reasonably think that he's not of any danger, to their public. Which, of course, every reasonable person would agree to this. Unless Partey's case goes to the full length and finishes and is guilty, then we can discuss something else. But at present, the case has not even started.
I see.
Because the man is down, remember. And it's very dangerous for first-class countries kicking a person who is down. When you are fighting with people and they are down, you don't keep on kicking them when they are down. That becomes very dangerous. Because this is a man who, rightly or wrongly, would not have the right frame of mind. Right frame of mind. In fact, some people had even argued why Ghana even called him in the first place. But mind you, some people rise beyond reproach depending on their personality. Diaz's father was kidnapped. Liverpool said, listen, you are not in the right frame of mind. Your father is kidnapped. We're not going to fix it today. He said, don't worry. I'm bigger than that personality. He comes on, he scores a goal. Everybody and how they deal with the things they are going through. So I believe Partey would have a lot to prove to say that, listen, let me play, and you see that this thing, I've gone beyond it. I know my innocence. So nothing's going to happen to me. But the truth is, so long as Partey's matter has opened in court, he wouldn't be a happy man, especially when he knows that he's innocent. He keeps on standing by it. I'm innocent. I haven't raped anybody. That sexual assault is false. I'm innocent. You would agree that his right frame of mind would not be the right frame of mind that you and I will have when we don't have any court matters. So if you go ahead and deny him this on such frivolous reasons, what are you doing to this frame of mind? Not just against Panama, but against Croatia, against England, and throughout the tournament if Ghana progresses.
I see. Now we have the Foreign Affairs Ministry making some form of intervention. Does it work? Would it help?
It may, but unfortunately, I'm sorry to say that it's too little, too late. You understand? Because if I was dealing with this black, I full well know. I'll be 90% sure that they're going to deny him. I'll be 90% sure. He has to go ahead of time. America could have even denied him. It's the same thing that happened to referee Atan. I knew that they're going to deny him. Do you understand? There are people even in there. There are people in there in America now who went through the teeth. I have clients who didn't even have clients who were Iranians who didn't think that they had a chance to go. But we have to make subsequent applications, early applications before we make the applications that we need to make, and argue for clearance before. But I think that the foreign ministry didn't see this coming, So it's like we say, better late than never. We can only hope and see.
Well, let me conclude with you then on this matter of plea bargaining. I'm sure it's something that you've come face to face with in your practice in the UK. In this case, when Chairman Wuntumi's matter came up, people say for the way, Chairman Wuntumi, no plea bargaining. I'm wondering what it means when somebody says, because in Chairman Wuntumi's case, there's a suggestion from some lawyers who suggest that, it's not a plea of guilty. Can you have a plea bargain conversation without a plea?
That's quite interesting. I was hoping it doesn't go there. But let me sound this very clearly, even before. And there's a caveat I'm putting on before I even start this conversation. In UK, the kind of plea that we have is quite different from what America and Ghana practices. Ghana keep on changing. I don't know why they do that. I mean, the plea bargaining in Ghana is not even too long. But America is there a lot. America, they have a different level of law, different system. UK, we don't have those felonies in different degrees and misdemeanor and all that. We have summary and indictable, you see. So we have plea bargains, but we don't call it plea bargain, or it's not a plea bargain as we see it in Ghana and US. But we have sentencing discount and early plea. So, for example, if I wrong you, and the state charges me, it'll be me, then the crown, as in here it will be the republic, and America will be with the people. Now, if I agree that I've wronged you, maybe I've come to your house to steal, so I'm charged with theft. And if I agree right from the instant and I tell the judge that I've agreed, and so I would not want this to go in a full length of trial, the judge will give me about 25% discount of the sentence that I'll have.
25% discount?
25%.
Divide it into 4 parts and take one off.
Yes, you divide it into 4 parts and take one off.
Okay.
The reason is that you save the nation money, you save the nation time, because mind you, all criminal trials and prosecution are borne by the nation. The cost of the lawyers, the preparation, everything that goes in, and it's very expensive. Criminal litigation is very, very expensive. So you get a sentencing discount. Then final to end, we have what we call mitigation circumstances. Of course, there's an opposite side of it, aggravation. Mitigation circumstances. We get into the mitigation and see that, okay, I stole possibly because I was hungry. I stole possibly because my employer has not paid my money. That's why I went into the shop and stole this food. The judge may say that, yes, it's wrong, but we can understand where you're coming from. I did this because I'm homeless. I did this because I have a difficult past. I did it because my parents were in prison and all I've known is drug life. That's why I'm doing this. The judge will say, well, you've come from a difficult path. The judge can also do it. But UK, we don't sit down and say, okay, which, or what have you done wrong? So we can go into this bargaining and we come out through this. This way, or you pay this and all that. No, we don't have that in UK. Now, I put this caveat coming back on Wuntumi's matter. The truth is this. If you see people saying that people are going for plea bargaining and that they are not guilty, it's false. They may not be guilty on all the counts and all the offense. But they are essentially saying that save yourself time, and let me save myself time, and save the nation money by agreeing that this and this and that, I did it. But this is what I didn't do. That's why the bargain. So the state will also say that and say, no. The one you are saying that you didn't do, you did it. When you are saying that you took 10,000, no, it's actually 12,000. In fact, plus interest. So if we are working interest on Bank of Ghana rate of maybe 23 or 24%, this is what we're going to work on. Times the number of months that it has spent, compounded it, and this is what you're going to do. That's why it's a bargain. It's just like being in the market and haggling. So of course, when Tumi will come and say that, well, I didn't do it, or I did it possibly out of negligence. So charge me for being negligent rather than charging me for being criminal. It's two things. Or charge my company or the company not doing due diligence of what it did, or being incompetent in many ways, rather than thinking that we stole the money straight away. Then the prosecution will sit down and say that, well, we do not believe that. This is what we believe and all that. So if it doesn't work, prosecution say, you know what, both of us, we have interest in it. I have interest to convict you because the people want me to do that. The Republic wants me to do that. And you have an interest to be out there. Be acquitted because you know you didn't do it. Let's take it to an independent person where it was. That is the court. The court has no dog in the race. The court is independent. So the court decides what goes on. The court decides to go on jury trial for the jury to decide. Then sentencing comes and the judge gives the sentencing according to the sentencing guideline. Or the court decides to go summary of it and say, let's try it without a jury. So it's early days here. So I've heard people saying that, I'm hearing people saying that, oh, the Attorney General shouldn't accept this, Attorney General shouldn't agree. And no. Attorney General needs to listen to him and see what he's coming to say. What he's coming to say, if it works for Attorney General, he's going to wait with what the people want. If the people say that, you know what, bring the money back with a compound interest and go for 1 month or go for 9 months, or if you're able to pay extra amount of money this way, you're not going to get any imprisonment at all. Fair enough, that's what the people want. And Attorney General is going to do the best, what is in the best interest of the people.
I see.
So we can only monitor, to be fair, and see how it goes. I have seen some particulars going around. Attorney General has entered to the court saying that the defendant has come through his lawyers to request for this plea bargain. So I'm sure they will actually see what exactly his lawyers or Chairman Wontumi is coming to see, and from there make a decision. If it's good, from where I sit and in practice, if it's good, I think Attorney General should take it. And mind you, the plea bargain doesn't mean there's a wholesale bring the money and go scot-free. It can be both. They can bring the money and you still not go scot-free. It can be a reduced sentence. It doesn't necessarily mean that nothing else will happen. Or Attorney General can even look into it and say, okay, this man has about 3 or 4 counts. In fact, he has different other charges in other fraud as well.
Okay.
Let's try and take the money off here for the people, and with another situation, another charges somewhere, you can go and face that.
Okay.
But if you do not take it, what's going to happen is that if he's guilty of everything that has been charged with, he's going to get a sentence, which is all going to serve concurrently. So if he's given 10 years, it's like 30 years, 10, 7 concurrently is out in 10 years.
I see. That's interesting. But there are those who are of the opinion that when it comes to matters of corruption, we shouldn't even go there at all. Prosecute the person, go the full hog. Do you think that it should be taken off the table, considering how long some of these trials can take?
Yes, I think matters of corruption should be taken off the table. I have had it stand for many years. You see, because when people steal money, we don't know the kind of trade they involve themselves with the money, and they don't even share the profit with us. For example, I know someone very in the past. They would take workers' money and delay the workers of payment for about 3 months. They put it in some fund, something to flip it, to turn it. 3 months' time, it yields. They put the extra in their pocket. Then they bring the principal and come and pay the people. Sometimes they compensate them with a bag of rice and oil. Sometimes they don't compensate them at all. You understand? If it takes this money and you only will come and plead because someone is showing ruthlessness to say that I'll deal with it and I'll take the Republic money and give it back to the Republic. Then you come and say that I'll pay with interest. The question is, what business did you do with the money and how much money have you got? What shows that you're not even shortchanging us the interest? And who told you that you can take a loan from us without telling us? What if we didn't stand up vehemently? Now, who is going to pay the state? As we are going to award cost and interest, that will be the cost and the interest of the money, the principal and the interest. What about the state? What about the 50, hundreds of attorney general department lawyers working around the clock, making sure that they file what they need to file? The attorney general is deputy in court every time instead of being at work and from the office. What all this time waste? And he's a politician too. He might have some interest. Assuming that he wants to contest any position and all that, he may not be able to. It's a simple reason that he's in court, he's in the office and all that. Because of a single person, because of you. We shouldn't take this time wasting for granted. I don't believe
I lost you there. You're making a point, but we didn't hear clearly.
Yes. Can you hear me now?
Yes. I can hear you now.
Yeah. I'm saying, so I don't think that it is enough to say that let's do a bargain and whatever you've taken, you bring it, pay interest on it, everybody goes home. No, it's the cost goes beyond it. The cost goes even beyond the personnel that we've put in and all that. I don't think, and if to be fair, if you go out there and do proper survey with Ghanaians who know these matters, I am sure the vast majority will say, no, let's not take our money alone, but let's penalize people who have done that to serve as a deterrent.
What about if they give him a 25% discount on the sentencing? Would you agree he pays the money, interest, and the 25% discount?
25% will be too much because it's come too far. You understand? It's come too far. The case has been tried. You understand? It's still ongoing. If you want a 25%, you don't even start. So I think that if he's willing, and again, we're not being prejudiced to the court. We are not pronouncing guilty. We have to know that we are not pronouncing innocent. Okay. If he has agreed that we should end the case now, then some discount is important. It will be forming part of his mitigation. But how far he's brought the state, I think the state should be looking at maybe 5 or 10% is fine, but not a quarter of it. A quarter of it will be too much.
Thank you. Thank you for speaking to us.
Welcome.
He's a UK-based private legal practitioner, practices in the UK. I am Sena, SM will conclude, but so let me sign myself out. I am Sena Nombo, SM, Nancy, Eric, Patrick, Alaska B, the team. We say enjoy the rest of your day. We'll see you tomorrow. And of course, coming up next is DJ Abega with the mid-morning show. And stay tuned to Radio Gold 90.5 FM. Go nowhere. SM.
Name once and DJ Abega edit mid-morning show in Bebano. Mr. Oye Bema now or how Junso Untimin so ye padia may come for CB men capsules and a dear amount. Or basso so how I very romantic area of Viari Hono Peso CC of a fefe, but some so covichro how to now nemu may come for CB women capsules no and so at the amount. Mr. CB men is CB women who pay to the Ghana had say her bash of pharmacies and answer chemical show biano. Ubeti me any be at all eho. Ebia now will open the do me to aquacoton any of furniture mo or reprise venture so kaishi and answer for Susie about 4 0247 111671 0247 111671 and I say 0246 578750 0246 578750 Susie Aba Center Ghana ma enemy mase womo edamwase nti yakọ ama DJ Abega edit mid morning show no atwaso edi amamo.
Hey, Mr. and Mrs. The mama praise the Lord.
Hey, Pastor. Hallelujah.